Court isn't TV. Here's what's really happening in the Johnson County Courthouse. So first, you get charged, whether it's a C misdemeanor all the way up to a level 1 felony, and it's in Johnson County. You're in Franklin, Indiana. What do you expect? Well, first, you go to court, and you need to know what court you're in. And oftentimes, your initial hearing is going to tell you, are you in front of Judge Cummins, are you in front of Judge Rezner, or are you in front of Judge Kirkendall? But once you know, okay, where are they at? So in Johnson County, there is a courthouse. That courthouse has Judge Rezner, he's on the 2nd floor, has Judge Kirkendall, she's on the 3rd floor. But then separately, there is an annex that's across the street, and that has Johnson County Court 3, which is Judge Cummins' court. So you need to know where to be. You need to know which courthouse to go to. So obviously, if you hire us, we're going to tell you, hey, look, you're in front of this judge. They're in this room. I'll meet you on the 3rd floor for Judge Kirkendall. I'll meet you in the annex for Judge Cummins. So it's important to know where to go and what to expect. When you get in for both of them, you're going to walk through security. If you walk in with me by chance, I'm not going to walk in through security. I'm just going to walk right in, but you're going to have to go through security, and then we'll get to the courtroom. So generally in Johnson County, if you have a morning hearing, generally it's going to start at 9 a.m. For Judge Cummins, Judge Kirkendall, and Judge Rezner, most of them start at 9 a.m. in the morning. Most of them are basically, you call as you go. So they're not like, hey, it's 9 a.m. and then we're just going to start calling random cases. The way that it works in Johnson County, for pretty much all 3 of those criminal judges, with the attorneys ready, they're going to call you. So additionally, maybe you're in Franklin City Court, or maybe you're in Greenwood City Court. Those judges are also the same, where they're oftentimes just going to, once your attorney is ready, once your attorney tells you. So if I tell them, hey, Judge, I'm ready with this person, they'll get it called up. And those courts, Franklin City often starts at 9 a.m. Greenwood City, I believe, sometimes starts at 10 a.m. So it can vary, but you need to make sure you're there on time. And that's simply because if we get there and you're not there, we might have to get to other courts. I might have to get to other courts. And so if you don't get there on time, you might then have to wait longer than what you would normally have to wait. But additionally, you do want to be there on time because maybe the court has a really short calendar. There can be times that the court's like, hey, I've only got 6 hearings set this morning. And you get there at 9:20 and the court's been waiting on you for 10 minutes because all the other hearings were quick hearings. So make sure you're there on time. Also, avoiding any conflicts. If you have a reason that you might not be in court or you can't be there, you've got to let us know. Don't let us know the morning up. Don't let us know the night before, preferably. Let us know in advance. If it's an emergency, we understand. Absolutely, I will handle that. You tell me you've got an emergency and you can't be there in court, guess what? I'll show up in court and I will tell the judge it was an emergency and I will make sure you're good to go. But the more communication you have with us, the more we can kind of make sure that you're good to go. A warrant's not going to be issued for your arrest or a body attachment or any of these things. So none of the Johnson County judges really set hard discovery deadlines unless needed. Generally speaking, the Johnson County prosecutors are pretty good about, hey, look, when we get discovery, we're going to send it to you. They're not going to hold on to it. They're not trying to play mind games with you. Oh, no, we haven't gotten that discovery. They're not generally going to do that. So we don't usually have hard discovery deadlines, but obviously if the case gets aged, the court will say, hey, look, discovery's cut off if discovery hasn't been provided. And that can affect both sides. Maybe we have discovery that we need to give to the prosecutor. Also, just general deadlines. So the court, we might file a 10-day stay if this is an OVWI case, right? So now we have 10 days to file an SDP. So making sure we hit those deadlines, or if a court needs a motion by a certain time, motion to eliminate, motion to suppress, making sure that we hit those deadlines can be important. So when we look at negotiation windows and kind of how to get some leverage, again, 95% of cases are resolved in some form of a plea. And so what we do when we prep a case, we are always prepping that case for trial, but we're also trying to set you up in the best possible way for a plea on the back end. And so what can we do to kind of mitigate? And these can be like, hey, let's go get treatment. Let's get treatment done before you take a plea. So that way I can tell the prosecutor, hey, look, you were going to tell him to get treatment. He's already done it. He was proactive in making himself better and making sure he's never going to commit an OVWI again, or making sure she's never going to commit domestic violence again. Being proactive could be really big in a mitigator. And additionally, maybe we need letters of support. Maybe we need to get letters that say, hey, look, he will lose his job if this happens or this happens, and here's why you should give him this. These are things that we can talk about, things we might need to do. And so kind of understanding how we can negotiate the case in Johnson County, what prosecutors might be looking for, can be really important. So as far as courtroom expectations, first thing is attire. Look, you don't need to be in a suit and tie. You want to wear a suit and tie? Great. I'll be in a suit and tie. You don't necessarily need to be in one. But I would say if you were to business casual kind of vibe, I don't want you in basketball shorts and a cutoff. That's not preferred. You know, I understand that some people, they're like, hey, I had to work this morning. I'm coming from work. Maybe I've had clients that are landscapers, things like that. They're going to be dirty. I understand that can happen. And the court is understanding if that happens. But if you're showing up and you look like you just rolled out of the gym and you're sweaty and nasty, the court's going to be like, look, this is a court. They're going to take offense to it. Now, does that mean they're going to send you to jail? No. But you always want to make sure that when you're in front of a judge, no matter which judge it is in Johnson County, that you are putting your best best foot forward. You don't want to give that judge any reason to dislike you. Additionally, phones. When you're in that courtroom, you're going to see the attorneys, the prosecutors, we are pulling out our phones, we are on our phones, okay? I'm checking on your case on my phone. I might be on my computer. I might be looking at XYZ. I might be mentally knowing the argument I'm making while I read something. If you're sitting in that courtroom, do not have your phone out. If you need to step outside the courtroom, you know you're getting a call or you need to text someone, do it. Courtrooms in Johnson County, they're not the kind of courtrooms that are like, once you're in court, you cannot leave. You can walk out of that courtroom, send a text, or hey, wave me down and be like, hey, I'm going to step outside. I need to go to the bathroom. I need to send a text. Great. Still have your phone out in court. Only speak through your counsel. That's probably the biggest thing. I know sometimes you're just like, I really want to explain what happened to the judge. Cool. Don't. That's the answer. Don't. You want to explain what happened? You tell me. I will then explain what happened to the judge if need be. But at the end of the day, until you're taking a plea or unless we're going to trial, you don't need to explain what happened to the judge. The prosecutor is the one that really is going to control that. The judge runs the courtroom, but you should never be talking in the courtroom unless your attorney tells you to talk. Right? If your attorney needs to ask you a question, they will do that. Sometimes the judge will ask you a question. Generally, that's fine. A judge is not going to ask you a question that they're like, hey, I'm asking you, tell me what happened. They're not going to ask you that unless you're pleading. But you do not speak in court unless it's through your counsel, because more often than not, you're going to say something and you don't realize when you say it, but you said something that isn't actually good for you. You thought it was, but it wasn't, and it actually sets you back in negotiations. So you've got court. Johnson County, you understand the courthouse, you understand where you need to go, you understand what judge you're in front of. Okay, what's next? Then what's going to happen with your case? If we end up going to trial, okay, is it going to be a jury trial or a bench trial? We'll explain to you at that time what that looks like, right? Because a bench trial and a jury trial, they look like different things, and they look different in front of different judges. More often than not, you're going to plead. So what is that plea going to look like? Are we pleading open to the judge? Is this a set term plea? Are we going to do a separate change of plea and sentencing? All of these can be determined by A, what judge you're in front of, court you're in, and also maybe what you're pleading to. Maybe we need what's called a PSI. Maybe we don't need a PSI. Maybe we need to do on our end a pre-sentence memorandum. Maybe we don't need to do that. So these are things that we have to think about when we're in Johnson County, and depending on what judge we're in front of, how to set you up best for success. So if you pick up charges in Johnson County and you have to go to Franklin, walk into that courtroom with a plan, not just hope. And if you want to have a plan, you want to know what's happening, you want to set yourself up best for success, call the Marc Lopez Law Firm at 317-632-3642. And remember, always plead the fifth.